themselves, falsified records, embezzled from the state, all of that. He ended up with 15 years in prison. Yeah, he put me away, but it got up to him. So, it's with all of this stuff, it's more in the hands of our Heavenly Father than it's ever in our hands. And you can have crooked judges, and the guy could bribe the judge, and all of that. But when he gets out from that, there's no telling what's going to happen to him. He's going to meet up with half a dozen muggers in the back alley that are going to leave him looking like a hamburger.
Yeah, I've been told that it's even a volunteer to take your fingerprints, so you don't have to give them your hand. Same thing with the TSA. Do you go through do you volunteer to be searched?
Well, I know that they don't have the authority for a lot of this stuff, and with regards to the fingerprints, I completely agree. And I posed the question at the Dallas County Sheriff's Department. I said, what statute is it that you rely on for summary brutality in lieu of the normal fines and imprisonment? Choke and puke question. You think about it. What statute is it that you rely upon for summary brutality in lieu of the normal fines and imprisonment? When I say I'm not going to give my fingerprints at the Dallas County Jail, instantaneously you got half a dozen guys on you. They will slam you to the floor, and a guy as big as a double refrigerator puts his knee on my neck. My face is mashed into the concrete. I'm passing out, black clouds going through my head. I got my arms twisted up behind my back, all of that. Okay? And that came when they did something like this to me, when they tried to get me for unauthorized practice of law. And amazingly enough, they basically tortured me and everything else. Now, here comes the funny part. Comes time when that you get out, okay? And this deal was only 3 days long, but it was bad. So on the third day, I'm getting out. And this guy is standing beside me, a black fellow, young guy. He says, I said, this is really funny. He says, you being here. And I said, what do you mean? And he said, well, we were together when you booked in. And he said, this is the first time I've ever booked out with the same guy I booked in. And I said, oh, so you saw what they did to me? And he said, yeah, I sure did. And I said, would you be willing to execute an affidavit, sign an affidavit to that effect? And he said, no problem. and they were like in a state of shock when they brought me back into, not brought me back, but that just put the kibosh on their whole deal when they started filing an affidavit raising the issue of torture. Okay? And there was another funny too, if you want to hear it. The guy who's representing the Committee on Unauthorized Practice of Law, he had brought this process against me, and they arrested me at the post office and put me in the Dallas County Jail and brought me in the next morning to court. And this attorney goes to the witness stand and testifies. And he says, I mailed this stuff to Mr. Fox, certified mail, and I have the envelope here. It was a 9 by 12 manila envelope. And he says, this came back, and I have it here, intact, and that I hadn't shown up at the court proceeding. And so the judge says, well, let me see that. So the attorney hands it up to the judge. The judge looks at this manila envelope, looks at both sides, it's still sealed. Pulls out his letter opener or scissors, I forget which. Anyway, he opens the end and pulls the document out. And he reads the document page by page. And then he says to the attorney, I don't see anywhere in here where you mentioned the date and time of the hearing. And the attorney says, I sent that a separate first-class mail. And the next question was, do you have any proof of service? And there was a stone silence for a moment or two, and then he says, and it went like a resounding thing through the courtroom, no. And their whole case collapses. You know?
I have another one. You want to hear that one? It's a known fact that a judge sits with a sword of Damocles hanging over his head with a fine silver thread. And he doesn't want to cut that thread. That's a fact. If you look at the trial of the football player, O.J. Simpson. O.J. Simpson sat in jail for a long, long time. And there's a Shakespearean play called King Henry V. It's very short. But there's a soliloquy in that. It's tremendously long. And one man at the time had to memorize this and say it. And it was quite a feat to do that. And in the middle of that, he says, the troops came into the town and they apparently beat the town up pretty bad. So that's the way I would say it right now. He said, they may defile virgins, and they may can't think of the exact quotation, but in the end of it, it says they do all of these things, you know, and he lists them. He says, but they have no wings to fly from God. And that was in 1600, okay? 1624, Shakespeare now. I've got a thing here that you might want to share with these people. I gave it to Susan that I carry around with me just in case I get hit. And it says Federal Court Defense for Tax Cases. This is for, you want to read it too? And then I can move for him.
Well, how long is it?
Just 1 or 2 lines.
Federal tax defense?
Yeah. Yeah, it's for willful failure to file. And I'll read it. It says, Your Honor, I'm not aware of any statute that makes me liable for the tax. Not the tax that places a duty on me. I can't read well, I'm going blind my lifetime. I see 2 words at the same time. And that requires me to file a 1040 form, individual form, or any other income tax return. What this does for you is 2 things. It asks the prosecutor, he has to ask the prosecutor to inform the jury. And the prosecutor can't do that because it's a general statement and it doesn't make you or me or anybody else in here liable. And they're charging you, not the world. So generally they dismiss the case. But if nothing less, it maintains your innocence and presumption of guilt. If nothing else, anybody wants to have coffee, we can have it.
So, yeah, I just started to explain this thing with Isabella Suarez, and that situation there, when she was facing trial and the attorney wasn't doing anything for her, told her to wrap up her affairs because she was going to prison on Monday. She was just going bonkers. And she told John McGladdery what the situation was. And he said, you need to get Robert Fox here immediately. So she, covered the airfare at home, and we come to Chicago. And I arrived Saturday night. And trial was going to start on Monday. I left basically one day, Sunday, to get ready. And so I explained first off to Isabella Suarez that she could still do okay and that she was not going to go to trial on Monday if she could keep straight on just one liner. I said, all you have to do is keep straight one line and you will not go to prison on Monday. And so that got her attention. And I said, first off, what we got to do is get rid of the attorney. And I said, I got the paperwork for that, okay, blah, blah. And then I said, the judge is going to be put in a position where they're going to have a real problem, and he's going to try and make you move forward pro se. And he's going to say stuff like, you're going to have to represent yourself pro se. So you hear any of those words, whether it's pro se or represent yourself, so you hear any of that, you have to, your response is, I'm not here pro se, I'm not representing myself, I am myself. And the trick to that deal is this. If you got a coupon for a cup of coffee, can you drink the coupon? No. It represents a cup of coffee. If you eat the menu, your tummy will not be satisfied. It's merely the representation. What you want is the real, steak and eggs. Now, so we go there on the Monday morning, and she immediately files to terminate the attorney. And it was a heck of an experience, actually, because it was the first time I ever saw anything like this, and I never ever since. In Chicago, they had, how there's two parts. You've got the audience area and the action area in that courtroom. And you got the communion rail. That's in most courtrooms. But there in Chicago, it was bulletproof glass, floor to ceiling. And you've been there? No? Okay, well, that's what it was. It was bulletproof glass, floor to ceiling. The audience got sound via speakers. The judge had the switch at the altar. If he didn't want you to hear, he just switched it off. And you're watching a silent movie in a glass box. I mean, it was unbelievable, but that's the way it was. And I assured Isabella Suarez that I would be with her if I could. I said, but there's no telling what kind of reaction the judge is going to have. So we get up there, and by the way, I've been with a lot of people and had success, but in this particular situation, she and I go up there, the judge takes one look at me and he says, are you an attorney? And I said, no. And the bailiff was already coming towards me. The judge says, well, you get back in the audience area. And he had that kind of tonality that it's like, you're going to be back in the audience area or the bailiff's going to put a few lumps in your head. And I could tell that there was not going to be any progress in this outfit at that time. But I had already instructed Isabel Suarez in this matter. And I also told her, last one who speaks wins. And I said, this guy's going to try several times. So she's up in front of the altar, face to face with the judge. She's having a knee-knocking experience. Her whole family's at stake. And the judge says, "Oh, I see that you fired your attorney, and we have a jury pool of 50 jurors here, and there's been too many continuances already, and there's not going to be another continuance, and that's that. And since you fired your attorney, you're just going to have to represent yourself pro se, and that's it." And she says, "No, I'm not here pro se. I'm not representing myself. I am myself." He was like flabbergasted, and he tried again and again and again. And to her credit, she, every time, just like I told her, anytime you hear those words, "No, I'm not here pro se. I'm not representing myself. I am myself." And this happened like about half a dozen times. And suddenly, something different happened. Suddenly the judge, from his mean, ferocious, tyrannical character, all of a sudden he becomes like Grandpa at the fireplace at Christmas time with his favorite granddaughter on his knee. And he says, "Zoila," no, it wasn't Isabel Suarez, it was Zoila. Yeah, that's the correct name. Zoila. He says, "Zoila," he says, "here in Chicago, we have these incredible skyscrapers. And at the top of these skyscrapers are the finest attorneys in the world. So, Zoila, if you would just pick one, any one, the most expensive one you could find. Here's my business card. Call me. And when you pick the attorney, just call me and I will call that attorney and explain to him that it's his turn to do pro bono work for you, Zoila. And that means that you will not have to pay anything. And you'll have the best attorney in the world." And, so she takes the business card and we went to lunch. and later, she prevailed. Because there are some attorneys that are like $10,000 an hour. And they're not in the business for losing. They couldn't stand it on their record. So, let's see. So
6 minutes.
6 minutes.
Take some questions.
Okay.
You mentioned that you put in an affidavit on the issue of torture, and I wanted to know after that, how do you stand on those documents, and what are you telling them to do to make amends for that?
Okay. I was in open court, and I didn't know then what I know now. And so I raised the issue, and the judge was telling me that they had immunity. And that because of their immunity, they were dismissing my action against these attorneys for what they had done to me in Dallas County Jail and so on. And so he was dismissing it. But I could tell by the look on his face that they were really, really concerned. And So I didn't get where I needed to get on that case because their claim of immunity. But now I know there is no such thing as immunity for a criminal act. And I was just overwhelmed at that particular time, you know, because I was up against a whole battery of attorneys, and the judge was already ruling in their favor, which never should have happened. And I knew it wasn't right, but I didn't have my ducks in a row at the time to really fight him on that. And it still exists as a possibility. I also had some experiences too, like I had mentioned the thing with the State Department. I beat the State Department, and people asked me, well, did you sue them? Yes, I did. Some interesting things happened. The guy from the State Department that swore out the criminal complaint against me, they transferred him to Vienna, Austria. Gone, like that. The prosecutor, the female prosecutor that Mike Wilson trained, she disappeared. Gone for years. And as far as me suing them, I was rearrested, and they put me through such a savage beating that they broke my back. One of the guys that had beaten me up the first time at the Dallas County Jail, he came and stood over me on the floor with a broken back. And this guy comes and stands over me and says, "So, Mr. Fox, are you going to appeal now?" You know, they do that kind of stuff. But I don't give up. And so, you know, I'm still working on suing these jerks.
Since we only have 3 minutes, I only have 16 questions. I waited patiently now, okay? I got
That counts
questions
a lot.
in a row. Yeah, right. So do we go through this today, or whichever one you choose to answer? We went over the mental evaluation, but there was no comment to whether or not you can have your mental evaluation before you go to court, and there's like a statute of limitations. In other words, if you get a mental evaluation in the last 3 months or 6 months, then you get to pull a new one. Is there such a term?
Well, I think that if it was a long time, you know, they might be able to raise that as an issue, but, you know, if you know that something may come down,
Yes or no, please.
when they do that to you in court, the answer is, I swore an oath to tell the whole truth, and if yes or no does not cover it, then I need an exemption or an immunity from perjury.
Nor am I an adversarial witness. Therefore, they kept all that either. Anyhow, next one. Can you comment on why the attorneys don't have a license?
Why would they have a license?
I'm asking, can you comment on that? Elaborate a little bit.
Okay. Because they're running their racket, okay? And they're not about to set themselves up to pay any of us, like the riffraff. You know, they consider us down here, and they're an exalted status as an attorney.
So basically, all they have is a bar card?
All they got is the bar card. The bar card, I mean, if you get stopped on the freeway by a state trooper, and he says, "Let me see your driver's license," and you give him your American Automobile Association membership, what's he going to say? This is not a license, and this is not good enough. They have a bar card. All that is a professional association, and it's not a license. And if you get into a discussion with them, the question is, what state officer accepts the annual renewal fee, and how much is it? And you have a receipt.
Right.
They paid nothing. They paid for the bar, but the bar isn't the state.
And it's not
So
licensed.
who's issuing this license?
It's not under the Business Bureau.
Huh?
It's not under the Business Bureau.
Right.
Right. Once we throw his rocks on fire. No, okay, can we get a copy of the document for entry into the case? Thank you. You mentioned Mr. Lattery, John Lattery. Is that case published?
Pardon me? No,
No.
not that I know of.
We wouldn't be able to have access to it, or is there any way that we don't know?
It was in a suburb of Chicago. I think it started with a W, but I can't recall exactly. I'm not sure. I'm not sure.
Okay.
That sounds more like it. I'm not sure though.
Was it up north towards the, right off the lake?
I don't recall.
Okay. Well, if we do, maybe we'll talk about it by tomorrow. Going back to the mental evaluation, this thought was an afterthought, so why do you believe that the fifth, raising the fifth in the mental evaluation might be able to stop them on the spot?
Because you cannot be compelled to be a witness against yourself. It's like the Miranda warning. Okay? You have a right to remain silent.
Okay.
Okay?
So wouldn't that imply that even upon the proposition of undergoing such a mental evaluation, you can at that time decline or not volunteer?
Right. Right.
But they force it upon you.
See, okay, the difference between the two things, if you've got a mental evaluation that you could whip out in court and say, I've already got my mental evaluation, that stops them dead in their tracks. Okay, which means that you're going to go home to lunch with your wife.
Sure, it's understood.
Okay.
I'm talking about
But-
if they pull you off the road and then you end up in this, you get steamrolled and you don't have time to do this. I mean, none of us here expect to have a mental evaluation, right? I'm not just going to go carry one in my pocket for the next couple of years, just in case. So,
Okay, all right.
I'm just
all right.
saying,
I understand what you're saying.
Right.
Now, if you do get caught, like, they're not going to send you to a mental evaluation or a parking ticket, leastwise not that I've ever seen.
Oh, you want that?
But you get, yeah. But if you get into a ruckus with a federal judge about tax evasion, you'll be in a mental evaluation in a flash.
Well, times are tough right now. Nobody makes a buck. Anyway,
But you know what I'm saying? Even if you use this strategy, yes, it'll save you from the mental evaluation and radically shorten your time, but you could still be there for a month.
right.
You know what I'm saying?
Right.
Because the U.S. Marshals are kind of slow about getting you moved.
104 IQ, what can you expect? Facts put into evidence by testimony. It is my understanding that evidence is in order to be admissible, would have to have relevance.
Right.
Okay. So, to your statement where you say you have to have facts put into evidence by testimony, can we add relevant evidence? Because they'll say a bunch of crap.
Oh, yeah,
Let's take
it's
an
gotta
IRS
be-
case. They're going to have 15 IRS witnesses, and they'll state the facts. And what I'm noticing is that they state the facts of what they did, but neither one of them can state to the truthfulness of the numbers in the documents they reference. They come from some computer, somebody else entered it
Okay,
from this office down
On
office.
those tax cases, they'll never have the paperwork done right. They'll never have a lawful assessment. These are several points that they have to meet in order to have it be a lawful assessment. But they'll come into court and they'll say, well, we had this computation and we got such and such records. Well, U.S. versus Smith, you can refuse to allow them to bring in business records. Most people don't know that.
The judge does allow that, though.
Well, this is a case that says, no, they're not allowed.
Right.
And now, if you run into that situation, it's just like Don McCarley. He was denied assistance of counsel when the United States Supreme Court said, you can't do that. And yes, he was denied assistance of counsel, so he walks out the front door of the courthouse. You know, see, it sets up a heads we win, tails they lose situation. You've got it, what they have to do, what's right to do, what's lawful, and then when they break the law, well, they lose the case. So if they did what they're supposed to, they lose the case. And if they do what they're not supposed to, they lose the case.
It's our experience that in tax cases, what they do, the judge will allow the jury to see inadmissible evidence, and in the end, he'll advise the jury that this is the law, and the law says these guys have to pay, and you signed an agreement that you're going to take the law as I give it to you, and I'm telling you that the law says they have to pay, and that's about it. And he's the dictator at that stage in the game, and the jury convicts. And they don't seem to care that that's the issue, because now the world knows these guys went to jail, and 6 months later they win on appeal, but nobody knows that. On reversible errors, like you're suggesting, I'm assuming you're keeping out their evidence, or you're triggering the mechanism for reversible errors. Am I correct?
Right.
Very well. You mentioned a DWI case. I know why your clients got off. Would you like me to tell you? There were no celebrities. Okay. Now,
That's a good one. That's a good one.
Say that again.
there were no celebrities. Obviously, they need a celebrity to make a case carry the rest of us, right? So there's your answer. Okay, joking aside. You mentioned going to the grand jury. That we find that that's not an easy task, and they'll block you. And if you try to go to the grand jury when you're in a particular case, they'll attack you as tampering with the jury. Have you tried that many times? Do you know of a path that's easier, because the prosecution will disallow it and they'll jump all over you?
Well, as a matter of fact, that's what I was planning on discussing tomorrow.
Good.
When we go
Well said.
from the issue of indictment, arraignment, pretrial, trial, and sentencing.
Okay, thank you. Then you went on to affidavits, but in every case you've only referenced affidavits filed in the state courts. Would it be the same thing with a federal, or where would you file with a federal affidavit? In the particular court you're in, or?
Okay, when I was talking about Dr. Barry Brooks, that was federal.
Oh, it was federal.
Yeah, and I got another one here that I could share with you about a guy by the name of Jeff Skiba.
Sure. Will all those documents be available for everybody with copies, if we make copies? Or not
Well, we're
necessarily?
going to have to send out to get them, some of them made tomorrow, maybe, or I can. I've got a bunch of this stuff on an e-disc,
Great.
but we didn't have a duplicator here. I've got back in Texas, 1 in and 7 out, and but I was like swamped, and I didn't have a chance to create the disc. So
Can we make that available with the DVDs? If one of us offers to make a copy, just throw it
I
out.
was gonna send that with the DVDs.
Fantastic.
What was it again? What were you asking?
What was your question? Not important, they got it. It's on tape.
Filing those affidavits.
By the table,
Filing
okay.
those affidavits into the court,
Yes.
in federal court. what you're saying.
Right.
Oh, yeah. Well, in the Skiba case, I filed one document, the case was finished. And
The affidavit.
that was,
The affidavit. You filed the affidavit. We're talking about affidavit in federal
yeah.
court.
I've got a copy of it right here.
Great. In an IRS situation, this affidavit, can you kind of sketch what would go in there in that affidavit in an IRS case? Are you going to address that tomorrow? Do you have a case with IRS that such an affidavit was filed into a court and had this effect, or is not the case, does not apply, or can you elaborate on that?
Well, these cases may have some things different, but then there's some areas of commonality as well. Like Tim and Dawn's case, that's a tax case. But it's not like every tax case. That's where they denied me as being a witness.
Understood.
The judge denied.
That's why I'm now looking at the affidavit, because the affidavit in a tax case would be pretty much the same issue, cookie cutter, I would assume. Facts are different, there's circumstances, but whether there's a liability, duty, et cetera,
Okay.
tax, the affidavit would more or less be in the same vein.
On that, I have a little bit different approach than a lot of people.
Great.
I put together a page of questions for Tim, and he didn't ask the IRS agent this stuff because it's too ferocious.
You gotta be ferocious, those guys are monsters.
And I'm debating in my own mind whether we should even have that on recorded, because I'd rather almost that we just turn the recorders, all of them off, and I explain to you how to win those deals.
Show of hands, everybody okay with that?
Yeah.
We're
Let's
cool.
do it.
Yeah, we'll do that. We'll reserve, how much do you need? 10 minutes, 15 minutes, half hour?
Yeah, something like that.
Okay. On what basis did you fire the attorneys in the Isabella's case, or Isabella's, whatever?
Oh, that was Zoila.
Zoila.
Isabella Suarez was the one who was denied her medication. I just had it crossed in my mind. She was denied her medication at that federal facility, and the paramedics came and they wouldn't let him in, and she died, and all that stuff. But the one in Chicago
Zoila.
was Zoila.
That's the one I'm talking about. What was the basis for you firing the attorneys in her case?
Incompetence.
She didn't do it, he didn't do it.
Yeah, he didn't look at her evidence. He didn't subpoena her witnesses.
Okay, so those are technical. That's what I was asking, particulars. So this number one, number two, number three. So there were several elements that he didn't do his job.
And once you discover that they have no ability, or they're not going to exercise any due diligence for your case,
Right.
what do you need them for?
Yeah, well, the reason I'm asking is because we have a similar case in Northern California. There was a list of 139 questions asked, and they couldn't answer these questions. And the federal judge specifically said, well, look, we have these public attorneys here, and they're very competent.
Yeah.
And if you can't find, and they recommended Larry B. Kraft. The court recommended Larry B. Kraft as a tax attorney, and we found that quite intriguing. But
I'm sure all the other people that are in prison would also find that intriguing.
Yeah, well,
That's the ones that paid Larry.
yeah. Just for a quick comment, if I may, please. It really serves nobody for us to bash each other or to speak negatively of each other. I think time is for all of us to kind of pull them together. And if we show a little bit more understanding of the attorneys, maybe they'll try to understand a little more of where we're coming from.
That's like scorpions, right? I'm trained to
I refrain a different. I think we need to harmonize. I so happen to know they do have. They have good intentions, and whether they're misguided by previous education or not may not make a difference. Okay. All right.
Deep down, they're really good. That's why they bury them 12 feet instead of 6.
All right. There was another question, but it was not going to be placed by me. I have a young man who wants to say. All right, Jess.
I On a couple of those cases you talked about allocution, when those people walked out at their allocution, did the felony stand against them? And if so, is there a way to get rid of that?
That's a good question, and I am not sure.
Yes or no?
I think it probably dropped off, but I don't know for sure. You know, one of them, I coached a guy over the phone, for instance, Reverend Austin Miles in California. Apparently a lot of people know him. And, you know, he called me. He'd already been convicted. And his sentencing was coming up. And I coached him. He walked out the front door. As to whatever happened after that, I'm not sure. And I did get a letter from him, you know, declaring that, you know, that I coached him and helped him understand this thing, and that he was able to walk out the front door. Don McCarley walked out the front door as well. Now, I was involved in Don's thing from close to the beginning, but a lot of times the people will call me and they're already through a whole bunch of it, like Austin Miles was. It's already convicted before he made contact with me. And I've had a lot of cases where I'm only involved in a piece of it. And, you know, I don't know, I can't remember all of the stuff that I've been involved in, but some of the things are pretty amazing, like they were with Zoila. I'll never forget that one, you know. And there's another one, I mentioned Jeff Skiba. How are we doing time-wise? What are we doing on this?
We started a new tape, so
20 after, and
You ran out of time.
we're overtime.
20 after, so if you want to take a few more questions, you can, or you can, whatever.
If you're hungry, we'll bring you a cookie.
Got about 10 minutes and it'll be 5:30.
I have 5 questions. I'm always going to ask one.
Switch on.
I read a lot on the attorney's notice of appearance, and you mentioned the attorneys do have to make an entrance into the case. What exactly is the notice of appearance? Does it represent some kind of a trust, an insurance policy, some kind of bond? Do you know?
Good question. I don't know the
I know,
answer
I
to
just
that.
think there's more to it. And someone actually a few years ago did say it, gave me a huge explanation that at the time I didn't understand. But I just want to get to the bottom of what exactly the notice of appearance actually is, because I think there's a lot more to it than just an attorney saying, hey, I'm here.
You may very well be right. And, you know, I just don't know the answer to that.
Does anybody know, or know anybody that I can talk to that would know?
I've heard that. I had a case dealing with that recently, and I was asking the attorney themselves, because I was interviewing attorneys for competence, and I asked them if they knew what the difference was between representative counsel and the assistance of counsel, because I was not interested in representative counsel. I was not interested in becoming a ward of the court, and I was not interested in retaining their services. I was interested in possibly hiring them to assist me, that they knew the procedure. And this was something that I had learned from somebody. So I was just questioning him, asking that. So I don't know if the notice of appearance is a notice of representation, and letting them know that you are waiving certain rights, the right to speak, the right to talk to the judge. I don't know. That's just what my idea of it is. So I don't know if that helps.
A few years ago, it seems like they said something about that it goes into, it has to do with the trust and their bonding and all of that, but it was a big deal. And it's not something that you're just going to read in the rules of procedure or something. Anyway, I just thought maybe somebody might know.
Yeah, I wish I knew everything, but I don't.
Okay. And then you had mentioned earlier 5 types of affidavits. If you could talk about that tomorrow.
5 types of affidavits?
Yeah.
File elements.
Oh, it's 5 elements? Okay.
Yeah, we need to know that.
That's the same thing.
He gave 4.
And then in the beginning, and I missed this, you mentioned Rule 12.
Yeah.
Was the federal Texas?
Okay, it was Texas Rule 12, and that's just, you challenge the attorney. What Texas Rule 12 says
Is it rules of
is
civil procedure? Criminal
Civil,
procedure?
yes.
Okay, that's all. That's what I wondered.
okay.
Thanks.
But it's civil procedure, but you can use it anywhere because the concept agency is what is over everything.
I meant to mention this before. With agency, if anybody's studying it, you might also want to research public policy because that's where they're going to get you.
You didn't turn it on.
Yes, it is turned on.
It is turned on.
During Sue's case, we discovered that if an attorney does not enter himself into the case properly, he has no right to speak at any time during the proceedings. Period. And if you discover in your case and you search your records, that attorney has not entered properly into your case and gave notice to the court that he has entered into the case, he has no standing in that court whatsoever. He cannot speak in that court. He don't belong in there, out the door.
He's trespassing.
And everything he enters into the case
Is out the door.
restricted.
Has to be stricken.
So is that a document that he might have to enter into the case?
Notice of appearance.
It'll be right there on the United States versus you, and it'll be right on there. And his bar license number and everything will be there. And if you go back into the docket, there will be a place in the docket where he entered the case. If it ain't there, it notices the court that he's in the case as an attorney. And if he ain't there, he's not properly licensed, his bar license ain't there, he can't belong there. The federal court, they all in her case, speak of the devil, they all in her case said, oh, excuse me, I'm working under my boss's license. Well, guess who her boss's attorneys were? The guy who just got filed criminal charges against got fired.
Fast and
Mr.
Furious.
Dennis Burke.
Under the Fast and Furious scam.
The Fast and Furious scam. He's the one who stole $100,000 bail money from me that I bailed her out of jail with, and we're going to file charges against Dennis Burke and the court that he used that $100,000 to give to those drug lords down there to shoot that cop.
By guns.
Yeah, he used that money to buy guns with that he stole from me.
This is
They got to prove otherwise.
This is off the tape, I hope.
It's only me editing. Don't worry, it's only me editing. You talk to the editor right here.
Quick follow-up.
Now we get a charge, huh? This is how we make the buck.
Talking about the attorneys having to file an appearance, I did have a case in which the attorneys did not. I did file a motion in the court stating as such. And obviously, not knowing exactly how things should be done, we're finding ourselves in a situation that even if you do it right, or if you don't do it right, they still want to move forward. And I think that's one of the things I'm really hoping to find here is trying to get enforcement, trying to get some power, trying to get some authority. And that's why I really think that the agency is a very important part. But again, trying to get followed through, I think, is one of the problems I'm experiencing, and it sounds like some others are maybe here too.
What was your question?
I said more of a comment. What was the question?
In a case I'm involved in, there's an attorney says that she is the bank's attorney, and her name shows on the documentation where she files. But I went into the records and went and pulled all the records, got certified copies, and nowhere in there could I find anything that said she represented the bank, that the bank gave her authority to represent him. So, is she the attorney of record, or is she just BS-less?
Well, I can't tell from here whether she's the attorney or just BSing you. However, I think you'll be surprised to know, and we're going to run this by you. When the attorney says she represents the bank, and you make the challenge, and she comes back and she says, well, I got a letter here from the bank. Excuse me, any high school kid can create a letter from the bank. Get the picture? What you can do with computers these days is astounding, okay? So, yeah, Obama's birth certificate, thank you. So anyway, the attorney says, well, I got this letter here from the bank. That's worthless, that's not evidence. So then the attorney says, well, I got this check and I got this affidavit. Well, all affidavits, if you're in court, okay, and it's the showdown time as to where's the evidence, okay, and she says, well, I got this affidavit here. Well, all affidavits are hearsay until they're testified to. So it doesn't matter who signed the affidavit. If they're not in the courtroom to testify to it, it's hearsay. Next, what do you have? And so then, if by chance she says, well, I got somebody here from the bank. Okay. Well, if it turns out to be that they dressed up the janitor to put out on the witness stand, that's not going to work if you ask the right questions. Now, supposing it's somebody serious, a vice president or a CEO or something like this, and they get on the witness stand. First thing they have to do is prove who they are. Then they have to, this is one of the beauties, because I took training from over 50 top trainers, and John Nelson was amongst them. And John Nelson is off the scale. Comparing others with John Nelson is like comparing Cessnas with the Starship Enterprise. And I was tutored by John Nelson, and so anyway, when they raised this, that they have the authority from the bank, etc., because they got this guy on the witness stand. There's a case that John Nelson turned me on to, and it's called Osborne versus U.S. Bank. And this is an 1824 case. It's approximately 100 pages long. And it has a lot of stuff in it. For instance, all attorneys know that corporations must be represented by an attorney. But if you ask them where that came from, they don't know. Well, that's the case where it comes from. The case has been cited thousands of times and never overturned. And it's, like I say, it's from 1824. Now, what that case says is it addresses the issue and says that their whole authority derives from the charter. And the charter is the law for the corporation, which is the bank. And if they're going to show up in court, they have to have the law in their hand. So if they don't have the corporate charter in their hand, they got nothing. And furthermore, the CEO who's on the witness stand has to not only have the corporate charter, but he also has to have the minutes of the meeting where he was delegated the authority to hire the attorney, and without all of that, he can't point to the attorney and say, and that's the attorney I hired with full authority. Now, you can see the kind of complications they have, because they come in, they're arrogant, they're lazy, and they're stupid. So when they come in, they don't come in prepared. And it's like the attorney in Dallas about the house and Bankers Trust of California. And I went like this, and there's nobody in this courtroom from Bankers Trust of California to verify what this guy's saying, and he lost the case right there. It took 10 days to get the certified win in hand, but that's what it was.
That's huge.
What's the other Osborne versus it?
U.S. Bank.
U.S. Bank?
Or Bank, U.S. Bank or Bank of the United States, I forget which.
How long?
1824.
Well, it appears I'm wearing out some people's ears.
See you tomorrow. Yeah.
Yeah, we need a break.
Yeah.
No, those are the considerate people. We want to stay.
Look, you'd have to talk to Ron and Susie about staying the night here in this room.
Everything is negotiable, right?
I want to hear about the IRS. Can we turn the recorders off and do that?
Well, those other people left.
How about tomorrow? I think we have a lot of people that have flown in and they're tired and, get some rest.
Are you staying tonight? Because then we can do the first thing tomorrow morning if you're staying tonight. If you're planning on leaving,
He just lives down the street.
you got no excuse then.
All right, then. I guess we'll see everybody tomorrow at 9 o'clock.
Great, all right.